Okay, I hope my dog doesn't yap off, but if he does, excuse my apologies ahead of time. Okay, here we go. Read this out 3 times. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forum is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, or city or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Raise your hand, say your name, and state your position. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member of or agent of any law enforcement agency of a federal, state, county, or city or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Sounds like we're all clear. One last time. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forum is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict or false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, or town, city, or township agency present? This is also for a notary, poll worker, school board member, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, state your position. And then in the last time, or in the final time, we're going to end with a prayer. Please, Lord, give us eyes to see and ears to hear, ears to hear. And Lord, let it be done. Amen. Oh, there's my programming. Okay, Glenn, take it away.
All right. So I'm in the middle of doing a second amended petition or demand for relief with the federal court. And I've been doing a lot of research on the courts and using that WFAA TV case that we talked about last week. And so I figured what I would do is share some of the stuff that I've put in my document.
Was that in your mailbox when you arrived home from your journey?
No.
No? Oh, okay.
No, I was planning on doing a second amended demand for relief because I'm adding some more people, the State Commission on Judicial Conduct. Every member of the State Commission on Judicial Conduct, the Texas State Bar, and the Board of Disciplinary Appeals. Yeah, so I'm going to, I might cover some of that tonight. They're basically, what they do is they just go ahead and assault you, and they're not given a remedy. They're not doing anything about the bar grievances. It's an emerging dictatorship is what it is. And using Commerce Clause. And so, that's what I'm bringing up. But anyway, so this is my, it's not the beginning part of this petition, but...
Okay, hold on. I got to start. Oh, good. It's Just making sure everything is on record. Sorry about that, Glenn.
Okay, good. Yeah, I'm glad you're making sure, because it needs to be recording, that's for sure. Trying to make this as big as possible so people can see it. I could close that and then make it bigger. Just looking in the, yeah. So some of this text I actually took out of that WFA ATV case, but I modified it a little bit. So the Constitution of the United States, dated September 17, 1787, is still in effect and has never been declared void, and is the oldest written Constitution still in effect today, wherein Article 1, Section 1 states, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. And in Section 8, Clause 9, that's Article 1, Section 8, it states that Congress shall have power to constitute tribunals inferior to the Supreme Court. The Constitution had not, prior to the statement in the Constitution being written, since this is Article 1, provided for a legislative Supreme Court. They were and could not, without any doubt, be referring to our one Supreme Court, in and of the common law, which was already established and active in America and the United States of America. It's clear the Constitution is now setting up another set of courts called legislative courts, and they refer to them as inferior courts, meaning inferior to the already existing common law courts. Supreme Court. Article 1 of the Constitution did then and there set up legislative courts inferior to the common law courts, and is verified by Article 7 of the Articles of Amendment to the Constitution, wherein it guarantees, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by jury shall otherwise be reexamined in any court of the United States than according to the rules of the common law. This is so powerful, okay? They cannot, and there's no common law courts. They can't review what the common law court says. That's why the finding of facts, okay, because we find these facts.
Where did you pull that from? Where did you resource it from?
Sorry?
Where did you get that facts from? Or how, like, I know you've written on it before, but what was your original source for it? And how did you get it?
I've always said that when you're going to hold a common law court, you got to find facts, because they cannot rebut the facts. So just find the right facts. And so what I do is, when we hold a common law court, I prepare a proposed order or judgment or finding of facts. Of course, the common law jury can make any changes they want. That's what they're there for. But I prepare a proposed one, and so then they go through it, and if they want to make changes, they can, and if not, they just accept it the way it is. Sometimes they make changes, sometimes they take it the way it is. It's up to them. So, but that's the most powerful thing. This is the Seventh Amendment. And get a load of this. The Supreme Court, talked about in Article 3, establishes a legislative inferior Supreme Court of the United States for the District of Columbia, which is established by an act to establish the judicature courts, the judicial courts of the United States, approved September 24th, 1789. And the Code of Law for the District of Columbia 31, Stat 1189, March 3rd, 1901, establishes the Supreme Court of the District of Columbia, which is also known as the Supreme Court of the United States. And some of the judges, I'm not sure if all the judges are on both courts. The chief judge is on both courts, and some of the judges, maybe all, are on both courts. And you don't know which one. And the nature and jurisdiction is determined by the issues being presented. But the only true Article 3 court is our one Supreme Court, a common law court of the people, by the people and for the people, common law court, let's change that a little bit, of the people, by the people, and for the people, and was in existence prior to the Constitution. And this is Hale versus Hinkle. His rights are such as existed by the law of the land long antecedent to the organization of the state. This sets the courts of common law separate and apart from legislative courts such as this court or the 97th District Court, otherwise being a maritime court, in that any case tried in the 97th District can be reexamined in this court or the 97th District can be reexamined by action of appeal. This places this court and the 97th District Court as one of the inferior courts referred to by Article 1, Section 8 of the Constitution of the United States. Note the difference in a trial by jury in common law as to a trial with a jury in legislated inferior courts. The judge is in the inferior courts. Let's change that a little bit. The judge in the inferior courts instructs the jury on what they will hear and decide upon and what they will not. There is no such provision in common law with a trial with a jury. A common law trial by jury means the jury conducts the trial. The Northwest Ordinance of 13 July 1787, less than 3 months prior to the Constitution, which have never been altered by common consent or in any manner and presently remains in force, the last words of the introduction or preamble to the articles of the ordinances state, "It is hereby ordained and declared by the authority aforesaid that the following articles shall be considered as articles of compact between the original states and the people and states in said territory." So this is saying that this applies everywhere, and shall forever remain unalterable unless by common consent. To wit, the compact agreement is a federal injunction and is forever unalterable either by legislative Congress or its legislative Supreme Court or its other inferior courts or the administration. It is protected by Article 4, Section 2, Clause 1 of the Constitution for the United States of America, which guarantees the citizens of each state shall be entitled to privileges and immunities of citizens in the several states. Article 2 of the Compact states the inhabitants of said territory shall always be entitled to the writ of habeas corpus and a trial by jury and of judicial proceedings according to the course of the common law. The legislative law, statutory law, is in fact an extension of maritime law. The 1946 Administrative Procedures Act, Title 5, U.S.C., Section 559 at Sentence 2, requires the administrative law to be in compliance with and in conformity to the Constitution for the United States of America, and the common law with all its prohibitions, restrictions, restraints, and limitations imposed by its enumerated Amendment 9. Bounds and boundaries. Okay, and this Amendment 9 is, so what does Amendment 9 say? This is really good too.
Amendment 9 from what year?
Ninth Amendment.
Okay, what Congress or what time period I'm thinking?
Share it right now.
As we've spent time on here reading the Northwest Coordinates, so that's a good reminder for us.
Says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So, at common law, you have unlimited rights, okay? And so that's basically bringing in all your common law unlimited rights, Amendment 9. And the courts have ruled that U.S. citizens don't have access to the first 8 amendments against the powers of the federal government. Well, this is the 9th Amendment. And so they have complete access to the 9th Amendment. So this is like really powerful.
So I can throw that in the clerk's face when they say, we don't file that here. We can't put that on our record. We can't add that to your file. You need to talk to a judge to do that. That's where I'm going to throw Article 9 in their face.
The 9th Amendment, that's your unlimited common law rights. And I'm not sure how well that applies in Canada, but it certainly applies here. Anyways, so back to this, the legislative, right, the 9th Amendment. Okay, so the Maritime Code, otherwise known as statutory law, being administered as legislative inferior courts, this court in the 97th District Court, as evidenced by a maritime gold braid flag or the corporate seal in the courtroom, also acknowledges that when brought inland beyond the high water mark or the first bridge of any navigable river, they must be brought into compliance with and in conformity to the Constitution for the United States of America and subject to the common law. So that's what they're doing, is they're bringing these maritime courts onto the land. And when you bring it up about the high water mark, the Maritime Code only applies up to the high water mark and before any bridge on any navigable river. And this is the Judiciary Act of 1792. Saving to suitors in all cases the right of a common law remedy where the common law is competent to give it, shall also have exclusive original jurisdiction, cognizance of all seizures on land and other waters than aforesaid made, and all suits for penalties and forfeitures incurred under the laws of the United States. And that's 1 Stat 77, Section 9A. And this is also reaffirmed in the Judiciary Act in, I think it's 1930 or something like that, when they did the Judiciary Act, or 1929 or 1920. Anyways, of all causes of admiralty and maritime jurisdiction, saving to suitors in all cases the right of a common law remedy where the common law is competent to give it. And that's 36 Stat 1161, Section 256, Part 3. That's the Judicial Code before they came out with 28 USC. Thus meaning competent, common law is not extending in reverse of the high water mark or extending to sea or the jurisdiction of maritime law or to exercise jurisdiction as stated in the Constitution under Article 1, Section 8, Clause 17, where it declares that the inferior courts will exercise exclusive legislation as prescribed by Congress over such district, not exceeding 10 miles square, as may by session of particular states in the acceptance of Congress become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of ports, magazines, arsenals, dockyards, and other needful buildings. So that's where all of the courts, that's the only place they have authority, is in the District of Columbia. And Clause 18, to make all laws which shall be necessary for and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Therefore, all legislative courts, this court and the 97th District Court, only have jurisdiction in the District of Columbia under the Commerce Clause, which is why they use zip codes, which are only in the District of Columbia, and commercial paper, Federal Reserve notes, forced loans, which are only in the District of Columbia. And that's found at 12 USC 411 and the Gold Reserve Act of 1934, 48 Stat 344. Legislative, statutory, inferior courts themselves admitted the validity of the common law court in Strauss versus Strauss, 1941, which says, every system of law known to civilized society generated from or had as its component one of three well-known systems of ethics: pagan, Stoic, or Christian. Common law draws its subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we resolve domestic frictions and the rule by which all legal controversies are settled. Wherein we learned that law of the land means the common law, State versus Simmons, Justice O'Neill speaking for the court in Taylor versus Porter, Webster's definition of the law of the land at Dartmouth 4, Wheaton 518, which is affirmed by Article 6, Clause 2, which declares that this Constitution shall be the supreme law of the land. In Wiley versus Collins, acknowledges the common law and the Holy Bible from which it came, which is the foundation of common law, is our God-given constitutionally secured right. The 97th Congress declared the Holy Bible to be the Word of God by joint resolution, Public Law 97-280, 96-1211, Stat 1211. The common law, Article 3, Court of Competent Jurisdiction. Our one Supreme Court has issued an affidavit of finding of facts, which is attached to this demand for relief, which this inferior legislative court is required to recognize under Ex parte Milligan, which is superior to anything this maritime court can do because this legislative inferior court fails to be an Article 3 court. And this is Balzac versus People of Puerto Rico. The United States District Court is not a true United States court established under the Constitution, Article 3, to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3, of making all needful rules and regulations respecting the territory belonging to the United States. A true copy of which is attached here to it, Exhibit 18, all of which is incorporated herein by reference in its entirety. So, no legislative court is Article 3. And they have to recognize, so what you can do, and this is where I go next. This court is required to provide the demanded a Republican form of government, Article 4, Section 4, Constitution for the United States of America, as one of we the people. The demandant is a state in this union, because we the people are the state and have immunity against these County of Montague corporate thieves under Article 11 and Amendment. Now, let's look at Article 11 and Amendment. There's Article 11 and Amendment. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So what they're doing, since we the people are the state, right? So we're one of the United States, and all of these actions are brought by U.S. citizens, which are at a minimum, as actually the District of Columbia is not a state. Matter of fact, the Supreme Court in National Mutual Insurance Company, which is Tidewater Transfer Company, said that you don't get an Article 3 court when you're dealing with U.S. citizens versus state citizens.
What?
What's that?
Well, because they all take oath, they're all U.S. citizens, so how could any of them be in a national, American national, right? You're dealing with U.S. citizens in these courts.
I agree. But so, again, what you have to do is explain the law, and when you do it right, that's why why they won that WFAA TV case, because they brought these issues up. And that's why the court said it was res judicata. The court didn't have authority to override a common law court.
Yeah, they're all commercial courts run by U.S. citizens.
Yeah, that's right. So, and a republic form of government fails to include a District of Columbia Commerce Clause under Article 1, Section 8, Clause 3 because of Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square. And so because of Article 1, Section 8, Clause 17. The Northwest Ordinance was approved by the Continental Congress on 13 July 1787 as a compact, which is a contract, approximately 5 months prior to the demandant's fourth great-uncle Will Livingston ratifying the Constitution for the United States of America 18 December 1787 for New Jersey, which was intended to be part of the Articles of Confederation. So the Northwest Ordinance was intended to be part of the Articles of Confederation and forever unalterable, and all previous engagements entered into under Article 6, Clause 1. This is Article 6, Clause 1. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. So, again, that's where you get to bring forward the Northwest Ordinance, which includes the Northwest Ordinance, which is in full force and effect in Texas. And these county of Montague thieves and their bar member handlers engaged in the theft of the demandant's land with their forced rendition. And this is Hale versus Henkel. This is actually an investigation or some sort of investigation. And so that's why he says he has power to contract unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation. So far as it may tend to incriminate him, he owes no such duty to the state since he receives nothing therefrom beyond the protection of his life and property. So they have to give you protection of your life and property anyways, no matter what. His rights as such as existed by the law of the land long antecedent of the organization of the state, long before, that's what antecedent means, long before the organization of the state, and can only be taken from him by due process law and in accordance with the Constitution. So due process of law and in accordance with the Constitution. And so the immunity among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. So these Montague County thieves seized my land and there was no warrant. He owes nothing to the public. I don't owe them anything. And this is Redfield versus Fisher. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence and charter powers to the state, but the individual's rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. And their inferior legislative maritime court failed to be a trial by jury and absolutely failed to have anything to do with common law in violation of 1 Stat 77, Section 9A, and 36 Stat 1611, Section 256, Part 3. And it is an administrative hearing that failed to have an Article 3 judge, but was an executive branch administrator, which means any decision was a bill of pains and penalties, which is similar to a bill of attainder and prohibited. Each of these wrongdoers and their bar member handlers are required by their civil laws to be U.S. citizens. And anyways, so now I go into a little bit of history. And we've talked about this before. Does anybody have any questions about any of this so far?
Hey, Glenn, I have a question. Are you going to be around next week when I come back up to Fort Worth?
Yeah, I'll be here. I'm back from New Jersey now, so there'd be no reason to go anywhere. Although I've been thinking about going to Arizona for Christmas, but we'll see.
Okay. Well, I'm probably going to be there for a while, so we'll get together. And I'd like to look at this document some more. I'm about to file the challenge jurisdiction against the tax debt collector scumbags, and it's 28 pages long now. That one I based it on yours.
Well, I would shrink it down. Matter of fact, I would just cut to the chase. I would this document, you got to read this WFAA case, and it's the WFAA case is attached. It's pinned on my channel or on Queen's group here. If you go to my page or my page, it's pinned at the top. I would highly recommend you download it. There's a motion to dismiss because it's res judicata. That's a 1-pager. And then there's a 3-page notice of non-jurisdiction and of no jurisdiction and no venue. And then there's a 5-page memorandum of law. And I would highly recommend you read those things. I don't bring up the Uniform Commercial Code because it's not relevant. But you can, but the other stuff that's in there is absolute gold. And I would recommend you download that thing. And it's only like about less than 10 pages. And
I think you sent it to me before, but I haven't really had a chance to dig into it. But the challenge jurisdiction that you gave me last time we met, that's one I've added to. But there's reason why I've made it so long is because the other things that I'm doing that they're not really aware that I'm doing, but once you're aware of it, it's clear as day. So
again, if you make it too long, they won't even read it.
Well, that's their problem.
Well,
it's wild, and if they don't like it and they try to rule against it, then I just remove it to an equity court, a true equity court.
There's no equity courts. They're all maritime courts. Yeah, they're all equity actually, but they're the
statutory equity, and they don't have jurisdiction because they're not within the District of Columbia. So
they're all within the District of Columbia.
That's but they've exceeded that out in violation of the Constitution. They've done it by contract.
Yeah, with their extortion racket.
Right. So anyway, we'll talk later. I didn't want to bother you, but I just wanted to chime in for a minute and see if you're going to be in town. I'm heading back.
Yeah, I'll be in town. I'll be available for a donation.
Okay. I'll talk to you soon.
Okay.
Bye.
Okay. So, anybody else have anything? We can continue going through this, but this is just basically going through a little bit of history, and we've gone through this before. This is actually, even if this legislative inferior court could operate as an Article 3 court, this case is, quote unquote, not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, 1948, because the wrongdoers are all in the District of Columbia as government employees.
I got a quick question, Glenn. Often I've heard that common law is judge-made law. Is that true, or how are we able to influence the common law in the admiralty court when common law now is equivalent to, like I said, judge-made law?
Well, it actually is, but it's not judge-made law. There's different, depending on what court you're talking about, there's different types of common law. Okay, there's a common law of the federal courts. There's a common law of the state courts. We're talking about the common law of England that is made by 800 years of jury trial decisions. Okay, that's not judge-made law. That's trial by jury made law, and that's the difference. And so, common law is we the people, and so in some courts it's judge-made law. There's no doubt about it, but that's not the common law we're talking about. So
how would
common
you
law can mean a lot of different things.
how would you make that distinction if they're just going to use a precedent and file it over? I'm in Denton County, so they don't they don't follow the law there either. They follow their
I
own
agree.
rules and regulations. So
They
I'm in Denton.
again, what they do is you have to, we the people make the law. If you read all of these court cases, go back to another court case, go back to another court case, go back to another court case, and if you follow those court cases, you read those court cases, it'll always go back to a common law jury. In fact, in 1802, the U.S. Supreme Court convened a jury because there was an issue before them, and I can't remember which case it was, but there was an issue before them that had not been previously decided. Judges cannot make law. All they can do is compare it to an existing case, to another case, and say, well, this case is similar to these other cases, and so this is my ruling. You see what I'm saying? They
Yeah.
cannot make law. All they can do is interpret it that way. And but we, the people, can make law all day long.
Now, is this
We can.
document that you're going over right here, is that available for review, or is that a?
Well, this is my lawsuit
Oh, okay.
that I am preparing. I'm actually going to do a video on this, a PowerPoint presentation and a video on these courts. But I haven't. I right now I'm in the process. I gotta. What I have to do is once I'm done tweaking this, then I'll print it and I'll file it. And this is an amended demand for relief. And so
You had some great cases, because I'm trying to do something in Denton County, Texas. Not, of course, not similar, but along those lines. But it's been hard. You can't challenge their jurisdiction. Well, I don't know how to challenge their jurisdiction. That's because they're not operating in the country. Go ahead.
you're right. They're not interested in justice. What I would do is I would. I'll upload this, but this is a Word file, and this isn't the final one anyways. It's going to get filed in the federal court, and so you have the case number, and you can go to the federal court and pull it up if you want once I file it.
So you're doing the case number, but you're doing the federal court, Texas? I always get these confused because, I'm in Denton County, the state district court, and then you got Texas.
Yeah, this is federal. Yeah, there's there was a friend who's a disbarred lawyer that called me up when I was in New Jersey. I was riding bike on the boardwalk, and
Nice.
he had someone that wanted to talk to me that was from Buffalo, New York, but living in Canada. And they told me about some lawyers who had torn up their bar cards and were traveling without registration on their vehicles and doing all this stuff about common law once they understood what was going on. There is good lawyers out there that just refuse to do that stuff, Anyways, these lawyers had torn up their bar cards. There was like 2 or 3 of them that he talked about. And he said that what he said, which is very telling, he said if they get attacked by any state official, they automatically just take it into the federal courts, okay, because they're federally protected rights, and they're violating federally protected rights, and you can break it off in their ass, and they don't even try and deal with it in the state court, and so they take it into federal court. And you can do it a couple ways, like mine. Mine is brought as a collateral attack. You can remove it into federal court. Again, you have to justify it to the federal court as to why it needs to be there. But you can remove it into federal court, or you can do a collateral attack. And if it was a collateral attack, I just uploaded the Word file from this lawsuit that we're talking about to the group. So you can look at it. You can download it there. but it's going to change. There's little things I'm changing. It's mostly where I want it, but there's still stuff that's going to change for sure. But anyways, the point is that these lawyers automatically, they don't even try and deal with it in the state courts. The state courts are extremely corrupt. The federal courts are, that's where they get a remedy, is in the federal courts. And the argument is, again, is you have immunity under the 11th Amendment, okay? Because I'm the state, I'm we the people, and we're going to talk about that. We'll talk about that more here as we're going through this. So, in 1861, the southern states walked out of Congress, and Congress ceased to have a quorum and could not conduct business. And on the 15th of April, 1861, at 12 Stat 1258, isn't that interesting? The 15th of April, Lincoln ordered Congress to reconvene under executive authority. And 3 months later, on August 5th, 1861, at 12 Stat 292, while operating under executive authority, Congress approved an act to provide increased revenue from imports and pay interest on the public debt and for other purposes, which is the act that they use for property taxes. So that's actually a federal act which precipitated all of this. And Congress has been operating under executive authority ever since. In 1871, under executive authority, Congress created a municipal corporation called United States for a government of the District of Columbia, 16 Stat 419, under Roman law. And now there are two national governments, one which Congress operates outside and independently of the Constitution, for U.S. citizens and resident aliens under the Commerce Clause, Article 1, Section 8, Clause 3. And this is the dissenting opinion in the case Downs versus Bidwell. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. The Legislative Inferior Supreme Court ruled on a case that Lincoln failed to like, and Lincoln sent troops to the Legislative Inferior Supreme Court, which resulted in Rule 45. And Rule 45 says, all process of this court issues in the name of the President of the United States. That rule is still there in the rules. Therefore, there is no separation of powers, and everything is under authority of Congress, operating under executive authority, and this Legislative Inferior Court is actually the executive branch, operating under Roman law, and all officers of this Legislative Inferior Court are executive branch administrators. And this is, there's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command are crimes. The state of Texas is a municipal corporation operating under executive authority, which is a subsidiary of the United States Corporation domiciled in the District of Columbia, operating under the Commerce Clause executive authority. Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense and in the same enactment provide exceptions to its application. Congress passed the Code of Law for the District of Columbia at 31 Stat 1189, March 3rd, 1901, which is now known as the United States Code, which all courts, federal and state, operate under. The Texas Department of Public Safety, the State Commission on Judicial Conduct, the Texas State Bar, the Texas Bar Foundation, the Board of Disciplinary Appeals, and the Bowie Independent School District are all subsidiary corporations to the State of Texas Corporation, which is a subsidiary to the 1871 corporation called United States, and all bar members perjure their oaths at the drop of a hat by bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. This Legislative Inferior Court is operating under the Demandants Authority because Will Livingston, who ratified this Constitution for the United States of America on behalf of New Jersey, 18 December 1787, is the demandant's fourth great uncle, which means the demandant is posterity, as found in the preamble, and the demandant's entitled to right of blood, and no civil law can destroy right of blood because all of the laws in Texas are civil laws. And this is Bouvier's Law Dictionary, a maxim of law, the right of blood and kindred cannot be destroyed by any civil law. And this court is under power which is derived from the demandant as posterity, and the maxim says the power which is derived cannot be greater than that from which is derived. It's in the maxim of law. Therefore, the demandant failed to give any of these wrongdoers or their bar member handlers or this court any authority over the demandant. And John Marshall, the chief judge of the Legislative Inferior Supreme Court of the United States, agreed and said it's impossible for the demandant to confer a sovereignty which will extend over him. And this is McCullough versus Maryland. And it says here, the sovereignty of a state extends to everything which exists by its own authority or is introduced by its permission. But does it extend to those means which are employed by Congress to carry in execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They are given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. And the demandant is exempt from these County of Montague thieves, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. This is so powerful. Kawanakoi versus Polyblank, U.S. Supreme Court, 1907. And the demandant requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, which is the supreme law of the land. Anything in the constitutional laws of any state to the contrary notwithstanding. And we, the people, failed to be U.S. citizens because a U.S. citizen failed to exist when the Constitution was written. The term citizen of the United States must be understood to intend those who were citizens of a state, as such after the Union had commenced, and the several states had assumed their sovereignties. Before this period, there was no citizens of the United States. There are actually two classes of citizens because at the Revolution, the sovereignty devolved onto we the people, which the courts have affirmed, Dred Scott versus Sanford, Yickwo versus Hopkins. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects and have none to govern but themselves. The citizens of America are equal as fellow citizens, joint tenants in the sovereignty. And that's Chisholm versus Georgia. And the courts have ruled that the demandant can be a state citizen without being a U.S. citizen. One may be a citizen of a state and yet not a citizen of the United States. One may be a citizen of a state and yet not a citizen of the United States. There's a bunch of cases that talk about that. Both before and after the 14th Amendment to the federal Constitution, it has not been necessary for a person to be a citizen of the U.S. in order to be a citizen of a state. The Civil War martial law gave Congress operating under executive authority rise to some emergencies, which resulted in the current 13th, 14th, and 15th Amendments. And the 14th Amendment turned things on their head. And this is Colgate versus Harvey. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. But the 14th Amendment failed to affect the original state citizens. And this is Maxwell versus Dow, again, U.S. Supreme Court, that there was a citizenship of the United States and a citizenship of the states, which were distinct from each other depending on different characteristics and circumstances in the individual. But it was only privileges and immunities of citizens of the United States that were placed by the amendment, the 14th Amendment, under the protection of the federal Constitution. And that the privileges and immunities of citizens of a state, whatever they might be, were not intended to have any additional protection by the paragraph in question, but they must rest for their security and protection where they have heretofore rested. So the 14th Amendment didn't affect anything to do with state citizens, and it continues to this day. Privileges and immunities clause of the 14th Amendment protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship, and that's Jones versus Timmer, 1993. U.S. citizens are created by Congress and therefore corporations under the Commerce Clause. The term resident and citizen of the United States, as distinguished from a citizen of one of the several states, is in that the former is a special class of citizen created by Congress. So Congress can only create corporations. That's all they can do. And this is Public Law 100-418, April 23rd, 1988, definitions as used in this section. The term United States business means a United States citizen, which is why the Supreme Court has ruled that for U.S. citizens, the boundaries of the District of Columbia expand throughout the states of the Union. This is National Mutual Insurance Company versus Tidewater Transfer Company, U.S. Supreme Court, 1948. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington, District of Columbia, and through their plenary power nationally, that's dictatorship, folks, covers those citizens even when one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And in the Kavanaugh hearings, when he was appointed to the legislative inferior Supreme Court, he even said the government can go after a U.S. citizen in Afghanistan. Because U.S. citizens are created by Congress, they fail to have any rights not granted by Congress and are subject to the plenary power of Congress. Plenary. Court's full and absolute power over the subject matter and the parties in the case. Plenary, full, complete, entire. Plenary power, complete power over a particular area with no limitations. This term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress has granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. U.S. citizens do not have access to the first 8 amendments to the Constitution against the powers of the federal government. And this is that Maxwell versus Dow case again. The privileged immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. This is West versus Louisiana. The right of trial by jury in civil cases guaranteed by the 7th Amendment and the right to bear arms guaranteed by the 2nd Amendment have been distinctly held not to be privileged immunities of citizens of the United States guaranteed by the 14th Amendment against abridgment by the states. And in effect, the same decision was made in respect to the guarantee against prosecution by indictment of a grand jury contained in the 5th Amendment, and in respect to the right to be confronted with witnesses contained in the 6th Amendment. The term citizen in the United States is analogous to the term subject in the common law. The only absolute and unqualified right of a United States citizen is to residence within the territorial boundaries of the United States. State citizens are the only ones living under free government, and the county of Montague corporate thieves and their Purdue, Brandon Fielder, Collins, and Mont LLP bar scum handlers, or the bar member bought and paid for whores selling their Just Us in the inferior legislative 97th District Court, or the District of Columbia clerks masquerading as judges in this legislative inferior court, are incapable of impairing the demandant's right to own land or any of the demandant's rights in this matter. State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right, and the state has no power to divest or impair those rights. In our country, the people are sovereign, and the government cannot sever its relationship to the people by taking away their citizenship. The demanded to see a bona fide contract. The Catherine there we go. With the Catherine Phillips notice and demand, and pursuant to the face of the bill of exchange, silver coin was converted to land, and all the rights and privileges of the original land patent were brought forward, true copies of which are each attached to the demand for relief, all of which each of which are incorporated herein by reference in their entirety, evidencing no privilege of discharging debt with limited liability, a contract with commercial paper, The rights of sovereignty extend to all persons and things not privileged that are within the territory. That's Carlisle versus United States, 1873. So anyways, some of this I start going off raving and ranting and stuff. So that's about, you know, it. There's some really good stuff here about that polyblank case is just like nails it. Whereas
So would you use this in the state court? But you say you wouldn't use it in the state court and got no shot, right?
Well, you can, but I would. This is like, you know, this is like 50 pages,
Right.
and so
Right.
there's a lot of stuff I'd take out of here, but the idea, the fact that you're one of the people, you read that WFA TV case, and he's got a 5-page memorandum that cuts to the chase and nails it pretty good. You could take stuff out of here and make another 5-page memorandum or 6-page memorandum, and they would have major problem. You have to. That's a maximum law that you have to exhaust your administrative remedies before you bring it into federal court. So you have to give these state courts an opportunity to deal with it, because that's all administrative. Okay, so you got to bring up these issues. But so you got to give them an opportunity to deal with it. Otherwise, the federal courts will just remand it back to state court. You got to exhaust your administrative remedies. So you got to show that you went and brought that stuff up, and they refuse to, you know, do the right thing.
It sounds great.
So, anyways, the Word file's uploaded, and that WFAA TV is pinned to the top. So I would, there's only there's less than 10 pages of the stuff that's the important stuff in there. I mean, there's a lot of good stuff in there about how to do a common law court. I mean, it's all right there. And so having a common law court is good. If you're in Denton, we meet every Tuesday for a meeting in Bedford, Tuesday from 11 till about 2 or 3. If you want to come down and meet with us, you're welcome to. Anybody is welcome to come and meet with us, and we share this kind of stuff at the meeting, and have people. Sometimes I speak, sometimes other people speak, you know. But yeah. If you're in Denton, you know, come on down.
Yeah, I'm in Denver, not far at all. Well, actually, I'm in Louisville, but
we're by DFW Airport. You're not too far from here.
Yep.
There's friends of mine that live in Louisville.
Awesome.
So,
so how are you making out with your common law court in Texas? Do you have a solid common law court formulated that you're ready to rule on cases now? I know that's where you were mentioning you want to formulate.
Half the battle is enforcing it, and so we have met. I've got several judgments, so now we need to enforce them. I don't want to really spend a lot of time on these judgments. We call a bunch of people together, and it takes time and effort. And so that's why I filed this lawsuit. That's why I brought this case into the federal court. So we want to get some victories out of it. Then once we see that we can get some victories and what we have to do to get them, then we'll do some more. And but we need to. The key is to we got to make them work, to make them so that we got the fake courts run and hide. You know what I mean?
Yeah, definitely. But you've got the folks that you've got the signatures. That's awesome.
Yeah. There's quite a little network of people here. We've got. Darren has an email list of about 400. Now, a lot of those people work regular days, work regular jobs, and so they're not able to come to our meetings because we're in the middle of the day. and trying to get a place to meet in the evenings when people are available is a lot more difficult, because we meet in a restaurant that has a room available for us, and the only requirement they have is that we buy something, and so and that's pretty easy, but in the evening those rooms are used, and they have so you need a room where you can have a little bit of privacy, where you can talk about this stuff and have a meeting.
Yeah, absolutely. Communication's the key. So, but you're the most advanced common law anything that I'm even aware of. So, just keep working on it for the rest of the nations and that are just so stuck in neutral, and not advancing where they should be in this avenue with courts.
Actually, and I'm going to share the screen here. We're probably in America, we're probably the most advanced, but this here is a common law court. In England, you can get passports, you can get driving credentials, you can get all sorts of stuff. And there's people that are getting them and using them successfully. There's a guy that I met when I was in New Jersey. He was a retired fire chief, and he got their passport and he went to Canada with it, and he had no trouble at all. And so this is, I would highly recommend you getting stuff from these guys. I'm actually thinking about getting stuff from these guys, because you can get a passport, you can get a driving credentials, ID card, you can get it all, and it's all common law. And so I'm really thinking seriously. I'm just, it costs a few bucks, they got to pay bills and stuff, and so that's been my holdup, is coming up with the money for it. But I would highly recommend these guys. For sure. I talked to the fire chief. There's other people that I know that are getting their stuff, and the fire chief said that he used the driving credentials all the time, and he's been stopped several times, and they just let him go. And this is in New Jersey. New Jersey is, if there's a draconian state, it's New Jersey.
We heard that from Nelson last week, didn't we? They're really being pricks to him in his little community there. Did he get back safe and sound? Is he good?
Yeah, he went back. He's been in touch with one of us, with Ken here, since then. He was talking to Ken today. But so he's back. He said he might be back here in a couple of weeks. It's the off season. His brother owns the beach houses that I stay at twice a year. And so it's the off season right now. So there's not a lot for him to do. He said he's probably going to be back in a couple of weeks. So he's fighting his battles, and he's got his way of doing it. I don't necessarily agree with what he does, but it's his way of doing it. So, he's got to do it the way he's got to do it.
Ironically, I have people in New Jersey, so I know what you're talking about in regards to the life there. Question in regards to the common law courts from Great Britain. How would one attain something without having the credentials for living there? You know what I mean? How are you going to get a driver's license when you don't even live there?
Actually, Great Britain and international, and common law is worldwide. Common law of England, is in every country that was previously a British Commonwealth of Nations. So Canada, Australia, New Zealand, USA. It'd be a little bit more difficult to try and use something like this, like in Brazil or Argentina. But you could certainly use it in any of the former, and that's like 150 countries around the world.
But would they
Uganda?
would they delegate you as a Great Britain citizen?
No, no,
You would just
no.
be a
They
state
don't
citizen from
actually.
your state,
I'm not even sure. I don't have their passport.
right?
That'd be interesting to see what their passport says. But this guy that um, that this guy from New Jersey, this retired fire chief, what I heard is they give you a born date. In other words, 9 months before your birth date is the day you were conceived, and so they put that date on their documents. And there's a bunch of little things. The guys are brilliant, and there's a YouTube video. Let me find the YouTube video. I would highly recommend you watch this YouTube video too, because it's by these guys.
Tell me it's not David Higgs.
Who?
David Higgs.
I don't believe so. It's a guy from Scotland.
Okay, good.
One of the
David.
guys that was at my event was a retired police officer from England, and he knew this guy. And here, let me share my screen. I would highly recommend. Matter of fact, I'll put a link to the video in the chat too. Let me do that first. I think I did that last week too. There, it's in the chat. And let me share the screen. Oh, you're looking at the screen. Okay, it's in there. So that guy is Scottish, and but he's only one of the guys. There's a bunch of people. There's like 100 people that have signed this document that started this common law court. It's really, I mean, that's really slick how they did it. I'm telling you, these guys got their ducks in a row. They're brilliant. I'm going to step aside for a minute. I'll be right back.
Okay, good. Maybe we can play it after Glenn steps away or is done for the night. I like the fact that it's an international court because I'm having difficulty just getting that many folks together in my zone.
Okay, I'm back. So, at any rate, so we're doing stuff here, and I like what these guys are doing. I think this is, if you know, quite frankly, you know, these people that want to capture the minor estate and all that stuff. The only thing I would say to that is caveat emptor, buyer beware. You're getting yourself into a contract with the devil, in my opinion.
Well, they
And
say that the enforcement lies within the taxation, because they're doing this through the amorty, which is all, you know, their payment through bonds, which they don't never register, and our enforcement, the only way that we can get them is through the taxation. Is
yeah,
my
I
what I hear.
don't. It's not something I want to do. I think that you're just getting in a contract with the devil, and I think it's a major mistake. But so that's why I don't go there. I think it's all satanic. It's all evil.
Do you have an EIN number, Glenn?
Absolutely not.
Okay, yeah, that's what I was assuming. I get it. I was correct.
Yeah. Sorry?
Oh, I was just asked if I knew if you had one, and I assumed you did not. So, thank you for confirming.
EIN number is employer identification number. I manage a trust and a limited liability company that has an EIN number, but I'm just an employee. At any rate, if there's nothing else, I suppose we'll adjourn for today.
Yeah, I was gonna play that video after you were done for the night, just to reiterate more about this common law court that, well, everybody is interested in, right? Everybody wants to.
Thanks so much, Glenn. I appreciate that. Appreciate your information. Really insightful. I'll try. Tuesdays is my worst day, of course. I figured that. Not until maybe next Tuesday, because I don't have school. I'm a school teacher, so I can't do it. But you guys meeting this Tuesday or once a month on Tuesdays?
Oh no, every Tuesday.
Okay.
Every Tuesday we meet. So, and if you want to meet for lunch sometime or something, you know, we'd be glad to meet with you and talk. You know, that's just because we're not having a meeting doesn't mean we can't sit down and shoot the breeze.
Cool. Yeah, because I get lunch on me since I'm in that. I'm in Louisville, like I said. Not that
But you
far.
should be in the email list for the Republic, correct?
Yeah, I'll tell you what. Call up Darren at 817-688.
Hold on, give me 1 second. Give me 1 second. Say what it is.
817-688-6700, and tell them you want to get put on the email list.
6700. All right, we'll do that. Yeah, not far at all. But I remember you used to do. You had your YouTube channel a while back. I remember hearing that. You had always had great content. And good to see you still doing it.
Oh yeah, the YouTube channel's still up. They took it down twice, and
right. I know
it's still up.
And your Yahoo group, I was a member of that a while back.
Yeah, Yahoo took all their groups down.
Yep, they did. I don't know why. And that was very informative too. So yeah, but got to keep on trucking, as they say.
Yeah, we migrated all that over to freelist.org.
Freelist?
Freelist, multiple, freelist.org. So you can go to administrating your public servants at Google Groups or freelist.org.
Right. Awesome.
There you go, Glenn. You've always bring some awesome information forward to us and keep us keep us thinking, you know. I want to be part of that common law court. I just have to be a member of Texas to do it, right?
I think that I came here to talk about this, and if I didn't, I would be in trouble. And so I have to.
Yeah, no. More people need to bring it forward. I know. I agree.
All right. Well, if that's it, I think I'm going to check out.
Thank you for the postings, and we'll be in touch.
Yeah, send me a link to, send me the video when you get it all straightened away, and I'll download it. I'm uploading these to my exclusive videos on HowTube, and at some point I'll put them on YouTube. Once I got to sue Google; they're blocking my access to it, so they want to be sued. It's in my bucket list. I got one lawsuit going on. I got to wait till the dust settles for this one, and then that'll be next. Anyways.
Yeah, I know the demanding of the phone number for everything is nothing plain of extortion. Yeah, no, I know. We gotta keep on
Hey
fighting that
Glenn,
battle.
I missed that link to that out of town thing, the out of country thing. I thought I screenshot it, but I didn't. Did you put that up in the chat for
Oh, you
the
want a link to that common law court?
International, yeah,
international court?
international.
I thought I had screenshot it, but apparently I didn't.
Okay, no problem. I'll put it now.
Sweet, thank you.
There you go.
Awesome. Thank you. I'm
Not a
I'm
problem.
gonna check it out because I think it's interesting to because we can't enforce. They have the discretion to allow the international in these courts because they're really not courts, and that's what I found out. We're trying to enforce international law on these courts, but they're just corporations. So it's hard to enforce the international law on them because they're not even part of any of the treaties that they're actually saying that they're supposed to go under.
Yep. So that's why that WFA 11th Amendment. You're the state. I am the state, and I've got immunity under the 11th Amendment.
Nice.
So, anyways, all right, you guys, take care.
Thank you.
You too. Thank you, Glenn. Have a good night.
You too. See ya.
So maybe Queen or somebody can play that video of that fire chief who is a common law, while formulating his own common law court. Is there somebody that can play that video?
I can play it for you if you'd like.
Please, that would be awesome. Thank you.
Did he drop it in the group?
He put it in his room, yeah.
Is that Wild Horse?
Yeah.
Hey, Wild Horse, how you been?
Hey, how's it going?
Doing all right. Staying alive.
So you're really that close to where they meet up, eh?
Yeah, it's a very small world after all. And I remember him writing some stuff about Texas. He was the first one that I saw his information where they said that the name of the corporate name of Texas is Cash Cow Enterprises. He was the first one I heard that. Cash Cow, truly, doing business as state of Texas. That's the name, and how could it be? Because they wouldn't let anybody just use the state of Texas as their name. You know what I mean? DBA Cash Cow is state of Texas, and when you look at it on the links, they used to have the links up where you could trace it, and it goes to all the different courts in the Texas area. It was amazing. Then they shut that link down. It was crazy. And that was pre-COVID. Now everything is pre-COVID, like AD or BC. BC or AD is pre-COVID, after pre-COVID or after COVID. But Glenn's been around a while. I haven't been able to utilize any of the things in there because most of the courts are admiralty courts. So how are you going to get common law into the admiralty courts? But you have to get their oath of office and then hold them to the Constitution. And I guess have a FOIA that says you're not a United States citizen.
Is this the video on the screen?
I think so.
Yeah, that looks like the dude.
And welcome back to the channel. Thank you for joining me in another of my wonderful interviews. Have you ever landed yourself in court and have you felt, blimey, this is a bit strange, everyone seems to be against me? And maybe they are. Maybe it's not the best place to be to argue your case or to bring somebody or even to defend yourself. Maybe we need something that was around in the past and seems to have disappeared. We've heard of these trial by juries, but very often turns out to be a jury trial, which is a very different thing. A name that has been bandied about and given to me, and I've seen online, is something called the Common Law Court. We've heard a lot about common law, and we discuss it on this show quite a lot. And a gentleman by the name of John Smith has been bandied around to me, and I thought it's about time I got him on the show and find out exactly what the common law court is that he is responsible for. So John joins me now. Hello, John.
Hello, welcome to the show. Thank you, and hello to all your viewers.
Thank you very much. Well, yes, as I say, I've heard a lot about the common law court. People have referred me to you, and I think at some point I've been on your website and had a look, but I've been on so many websites and had a look at so many variations of it.
Yeah.
I thought we should get into the nuts and bolts of what that is and what it is you do. Could you tell me what you consider your position to be? Are you the founder of this court or anything?
I'm just an individual member of the public like everyone else.
Right.
In relation to the common law court, I had taken on, having a lengthy career, I decided to take on my previous employers, and there was a dispute which went to court. Now, at the time, because I was licensed within this industry, to protect my license had left, but I went to court for the remainder of my contract. Now, what they did is they used the assistance of the government to attack me. And literally, says, while I couldn't work within the industry, I went to court to deal with it and lost everything, savings, house, lost everything, family. But what we did is I went to court myself after being bankrupt to deal with the sheriff in Scotland, which is the equivalent of your judges. And the sheriff had stated to me in court, it doesn't really matter what you think you are, it's a statement of the Lord man. He said, we have our own law here, and what you think common law is, it doesn't apply here. So he then proceeded to prosecute me. Now, that was it in a nutshell. So when I came away, and again, I'm not sort of backward at coming forward, but I thought, while I'm quite happy to deal with a judge on my own, not having been in court, what would happen to a family member, a friend, your next door neighbour? If they are not aware of how the system works and they want to go to court, like I did the first time, there exists no lawful remedy in the courts. I found out very quickly that not even courts, they're registered companies, but not only that, it's all done for profit. So when I sat down and decided, oh, this can't happen, I've tried literally every solution you can think of for the 12 years to try and get a result in the court to confirm that I was right. Now, without a doubt, this is after 8 years, I managed to confirm I was right. But what had happened is I suffered substantial loss that affected my family, friends, everyone. It's never been put right to this date, and we can confirm that I was right. However, given the feelings of the court system, I sat down and thought about it. I thought, look, we need to do something. So we sat down and had a conversation, myself and the partner, in 2016 on Christmas Day. And after about 12 years, we thought, we can't do this. We can't get on. We can't continue. You have to literally accept the fact that you're never going to win. So we left that and said, look, we got on with our lives. We can't waste more time. But the next day, on Boxing Day, I thought about it overnight and thought, look, I don't like this. I don't like what they're doing with people. I'm not happy with this. Look, I can't give up. We've tried for 12 years to come up with a solution. It doesn't work. You'll never beat them. It says, can we continue what we're doing for an additional 6 months? Now, if we cannot come up with a solution to beat them, or finally beat them, we'll just get another life. And literally within a couple of weeks, it came up with a solution. It's simple. It says if their courts do not provide a lawful remedy, and if their courts are fraudulent and a criminal and they don't exist for justice, don't use them. So we decided to create the common law court. Now, having spoken to many people and friends and people who knew a little bit about their system, we put together a proposal and say, what do you think of this? And it's clear, after speaking to a number of people within the UK, moving internationally, that they say, yes, you're right, you can do it. So I convened a court to deal with a dispute that I had on the Sunday, it was 11th of June in 2017. And when we convened this, what we did is we published a notice, a public notice to invite the public to attend. Now, I actually went down to Dunblane because I wasn't from Dunblane. I was quite a while away, a good bit away. But also, I didn't know the people were attending. So we advertised the fact the public just turned up. There's a procedure for running the court, but a jury was selected, court officers were selected, and we convened the first court. So we had the trial, and when we got the paperwork, we obviously published the result to make sure it was all above board. And when we published it, we made the mistake of calling it the Scottish Common Law Court, simply because it was based in Scotland.
Right.
We were contacted by people in the UK over the next month or so, and this is brilliant, we love it. Can we do this as well? So people in England, Wales, Northern Ireland say, we want to use it. I said, look, anyone can use it. It's basically a court of the people. You can use it, providing it's done lawfully. There's not a problem. But of course, they went on and on and on about it. So we changed the name so that we used to Commonwealth Court Great Britain. It was great. But of course, being people, over the next couple of months, we're being contacted by people in America, Australia, Europe, Africa. So we changed it one final time, and we came up with a name, which is Commonwealth Court Great Britain and International. So it covers everyone. From there, we actually have people using it from 188 countries. So the system was set up, but bearing in mind, I, like anyone else, yourself included, is just a member, a living man or a living woman. The Commonwealth Court itself is the people. That's it. That's where the authority comes from. And as I said, anyone can convene a court provided it's done lawfully. It's fine, and we've done so for a number of years. We've developed the concept, and we've now helped set up a community as well. So we've done this to protect the people, and we're having quite a lot of success.
I think that one of the things that obviously attracts people to something that is where the people are the in control instead of a private entity like the private bar guild is that it is run by the people for the people. Yeah. And of course people will identify with that. Why would a private company ever have that jurisdiction to be able to control people's lives? Yeah. The problem is that most people, I'm guessing, do not know that the court system that we have in this country is not only private, but is incredibly corrupt and is not really there to do justice, but actually is to act as a bank to try and get people's money. Where does the idea of the common law originally come from that you're using, that the people rather can use to convene the courts?
I think what we did when we realised the existing courts are not fit for purpose, we decided we have to do something, but we looked back over history and we looked at various sources. Even within the UK and England, they had an old system whereby they based the courts on local areas or parishes. From there it developed, and also the Crown got involved to set up the courts and proceeded from there. If you go back a couple of thousand years, people, obviously like Greeks, they were actually convening courts, and it was duty by trial. So what happened is, if your next door neighbour or someone in the village had stolen something from you, a cattle or anything, you had a right to obviously have them prosecuted. But the way it would work is the local people in the community would gather, and even over in Greece, what they would do is they would all gather for a hearing, and everyone would actually in attendance would be the jury. So the case was presented, obviously the plaintiff defendant would argue, defend themselves, and then what would happen is a decision would be made. And because it was from the community, they would then enforce it. However, as we've taken this, it's developed over the years, and again, within the UK, they proclaim to have a justice system which is unique to them. They set up, and they build themselves as sort of world leaders in the concept of law, which is ludicrous because it's nothing to do with law, and as you said, it's all about money. Look at the system and said, well, what we need to do is hand it back to the people. The people actually determine it's just whether or not you're innocent or not. You proceed with a case, you put it before a jury of your peers, which is the highest authority. They make the decision, and then we obviously try and enforce these decisions. But it was based on history and previously what happened. Now, this is also confirmed. The approach we've adopted as well is to go to the statutory authorities. The highest authority they have is the United Nations. Now, I'm not asking for an opinion on the United Nations, but basically says they are the supreme authority there. However, they themselves confirm that we can set up what we've actually done. And they verify it, even with the community we've set up, we're allowed to do that. So there's not a problem. So all we have to do is set up these courts, join the community, work together, and you can provide your own lawful remedy, which the state have to comply with. As I said just now, it's not something, we're not reinventing the wheel. This is there anyway. It was there in the past.
Presumably, there is a lot of pushback by those people in the legislative world who are very anti what you're doing, because you're effectively taking away what they think is power, which they shouldn't have in the first place.
Okay, well, I says we're having a conversation, but we'll have to be very careful with words, because we're saying that the state may not like what I'm doing, but it's not me who's doing anything.
No.
I'm not the Commonwealth Court.
Right.
Basically, I convened the court to obtain a lawful remedy, so I asked for the assistance of the public. Now, when the public came in, they would explain how the process works, to give them a detailed description. We went through everything, and then if they decided to proceed, they convened a court, and I put forward my case. Now, we've done this before, but the state, the things we have to get clarified for your viewers. The Commonwealth Court has not been, and is not a registered company. We have nothing to do with the state, nothing to do at all. But people keep saying, well, you're a registered company, we know you are. Well, it's not a problem. If we're a registered company, release the information and let everyone know. It doesn't exist. We're not a company. We can't be a company. So that's the first thing. Because we take on the state and individuals who have actually infiltrated as well, have came in to try and bring us down, attack us, steal from us. They've done that on numerous occasions. The latest ones that closed us for 5 months because of the website. But we've actually had everything secured and fully backed up, and each time we came back stronger. Personally, at this moment in time, there's currently a warrant out for my arrest because I actually went to court a few weeks ago, and basically when I was dealing with an issue, I convened the Commonwealth Court against the judge and the prosecutor in Scotland, which is called the Sheriff and the Procurator Fiscal. So they had prosecuted me in their own law, under their own law, and I said to them I didn't have an issue with that, but I'm going to challenge it because it's unlawful and it's illegal, and I'll challenge it. So we did that, but they refused to hear my challenge, and they done that. And because I kept pushing it, and I convened the Commonwealth Court against them, they didn't like the Queen's son of the papers. So they decided they were actually going to force the issue by forcing me to pay a fine. So they convened a court recently, and they issued a warrant for me to have a summons for me to attend. Now, I don't mind. It's because my view is they have no authority, they have no jurisdiction. I've confirmed my standing, and in relation to what they're doing, it's a contractual dispute. And not only that, but I'm out with the whole system because I'm in the community which the community was set up. So I went to court having produced paperwork, which I handed into the judge. And as soon as the judge and sheriff had said to me, he says, confirmed the state that there was a living man. And I then referred to the paperwork, which he refused to look at. He acknowledged receipt of it. And when he turned around and said, look, I need you to confirm that Mr. John Smith, which I wouldn't do. And I explained to him where I was. He says, I'm not accepting that, forget it. And he basically says, I'm issuing a warrant for your arrest. And he literally got up. I've never seen somebody move so fast in all my life. He left the court. Now, I spoke to the police who were in attendance there because we have police in Scotland instead of security guard. I says to him, is this judge, the sheriff, is he serious? He's got to be joking what he's done. The policeman says, well, you should have answered him. I said, but I did answer him, but he's not answering me, and he's not doing it appropriately. He said, yes. Well, he's issued a warrant for arrest. I said, that's fine. They said, well, we have a job enforcing that. And the clerk just said, you have to leave now, so we got up and left. Now, since then, we've filed criminal charges in their own system against the judge, the clerk, also the head of the prosecution service, and also the head of the legal system, which is like the Attorney General in Scotland. It's called the Lord Advocate. So this is currently the Chief Constable, which have asked for criminal charges to be raised. And again, given the paperwork we've put in, we've confirmed that it was in court, and what the judge has actually done, after speaking to me in court, the judge has confirmed that he's ignoring it and he's saying that I wasn't in court. Now, for your viewers, and may have heard the argument, and I've pointed it out to the judge and the police. The sheriff, the judge, was in court. He spoke to me. I spoke to him, and I spoke to various other people. He then says that he was issuing a warrant for my arrest. He spoke to me. Now, I've pointed out that if he speaks to me in court, and he cannot determine whether or not I'm there and I'm a living man, he must be mentally incompetent. And if he's mentally incompetent, he shouldn't be sitting there judging in this manner. However, I did actually say that in relation to being mentally incompetent, I'm going to give him the benefit of the doubt and say, well, I don't think he is. But if he's not mentally incompetent, that's confirming that he's spoken to me, he's accepted him a living man, he can't prosecute him. So what he then does is say, well, I'm dealing with the person. And because you won't admit to being the person, I'm going to issue a warrant for the arrest of the person, Mr. John Smith. So he said he would do that, but that's slavery, because he's taking a name, which is a person, Mr. John Smith, and he's trying to attach to me as a living man. That's slavery, it's fraud, it's criminal coercion. And again, at one point, he did actually threaten me with imprisonment. He said, well, the only reason I'm here today is to deal with this fine, and obviously to find out why it's not paid. And if you're not going to pay it, to decide whether or not I'm going to put you in prison. Which I laughed at, and I obviously referred them to my paper, and he said, I'm not looking at it. So therefore, there's no justice in the system. There's a warrant out just now that the Chief Constable is dealing with it. I'm trying to obviously prosecute these individuals within their own system, and we have a common law court order against the judge and procurator fiscal. Now, the court order we have, because of the work we've done, we've just established, is over a period of time, that the court order we have of common law is legally acceptable. Now, because it's legally acceptable, they have to comply with it. If they refuse to comply with it, under their own system, they're in contempt of court. And if you're in contempt of court, it carries up to, I think it's £1,000 or a couple of £1,000 fine, but also up to 2 years imprisonment.
Right.
Contempt of court. So we've passed it on to the police as well, but unfortunately they don't know what to do with it. So we're sitting there and still waiting for a response. Meantime, I'm sitting pushing this because rather than letting it go and just accepting it, we're actually pushing to enforce the decisions we have. And again, because we've got them to confirm that our documentation is valid and legally acceptable, is it means that they have to comply with the order. So there's quite a lot going on just now.
Yes, I can see that. But just going back to the practicalities of the people taking the decisions for what is lawful, particularly in their own area. I'm assuming that you haven't got to use the public buildings that are used by the courts, even though you could argue that those are our buildings. We've paid for them in our taxes.
Yeah.
So where would you convene your common law court? In a town hall or another type of public place?
Well, we've actually, effectively any building you do, what we suggest, if you have a building, it must be large enough to accommodate at least a minimum of 50 to the public.
Yeah.
The public have to have access to it. You then have to have a place available in that room to make sure that you can accommodate a jury and obviously the individuals, the officers and that. And then providing you have that, what we do is we ask for one additional room. Now the room is obviously just requires a table, but it has to accommodate the jury members. So when the cases been dealt with, the jury members remove themselves, go to this room to sit and adjudicate on the matter to give their verdict. Now, if we do not have an additional room, we use one large room. But when the case and the jury are going to be deliberating on the verdict, all the people in the room have to get up and leave the room to go outside until they're recalled, because the jury have to have a room for privacy. But you can use the one room as long as you clear it, or if the other side doesn't find out, you can have any room. We've actually used it all day in. We used, believe it or not, we actually got a social club. We found out it was actually the Labour Party. Now, we're not political, we don't mind, but we're actually trying to find a venue. So we're told about this club, which we went to, and we found out there was obviously a social club for the Labour Party. We went and we had a court hearing in Glasgow. Now, we were told again it was a sort of community room, a community building. So we went to the community building, which was fine. But we actually found out afterwards that the community building was sectioned off, and there was some car parking in the building. And next to that, there was a church premises. Now, we'd actually convened the court. It was for a public meeting, which we told everyone about. So they actually went about, we paid the fee. We came in and convened the court. We then published the information and prosecuted individuals. They had in turn contacted the building, the owners, and said, look, what's happened here? We've just got that paperwork. We actually found out that the owners of the building were in fact the church. So the church had kindly wrote this and said, look, all you've rented this building, that's okay. We didn't understand what you were doing, but we're stating now that we're not going to make that available for future use, which is fine, it's not a problem.
Right, yeah.
We've conducted cases everywhere, in hotels and social clubs and private clubs and community centres, so we do that. But obviously, we're fortunate enough with the help of people, have managed to obtain a building in Dundee. It's a very large building for what we're going to use for the community. We actually run an office here. The website, this is the website. We don't have a company, but the point being is when we have a common law court, for what we do to assist the people, we need to have something there. So you have a website. So I've obtained ownership of the website. We've created that. We've developed that with assistance of the people. And we've had assistance to get premises. So we have premises now, which we will allow the common law court to use. So basically, we have a building here, and we have convened a few courts in here recently, as over the last year or so. So the building set up here, it's ideal. We can probably accommodate 100 to 150 people in total. We have a jury room as well, and the building can be used for lots of additional facilities so for the community. So you can go to any building you want.
Yes, as long as the public have access and they're not being stopped to go in, which of course we've often seen in these so-called courts that we have up and down the land, that security are often not allowing a number of people in, or the court won't let members of the public, and it's not recorded so that nobody can look back. And I'm assuming that everything is recorded because it's on the public record.
Yeah.
So when you get to a decision You've presented both sides of the argument. As I understand, a trial by jury in the old-fashioned sense would be that not only is the jury coming to the conclusion of whether whichever side is going to win, but also whether the law that was broken or the law that has been brought to the case can also be changed, because it may be that it was just a nonsensical law, like a camera filming a bus lane or something that nobody normally drives, and at 3 o'clock in the morning someone accidentally went into it and they get a fine, and you just think, well, that's just stupid. That the jury can make the decision. Is that how it works?
Yes. Well, yeah. So we speak about laws. The common law works basically on the 4 principles: cause no harm to anyone, cause no loss to anyone, cause no injury to anyone, and ensure that you're honourable in contractual dealing. That's it. Now, the statutory law, the so-called laws that they have, you can take any statutory law in the world, and there's literally hundreds, if not thousands of them. Every one of them will fall under one of these categories. So all you need is these 4 laws: cause no harm, loss, or injury in contract. So the fact that they create all these laws is not done for the public safety or to protect them. It's done for money.
Yes.
Every law they have, you pay for everything. Now, as I says, as long as you have suffered harm, loss, or injury, or you've been on the receiving end of a dodgy contract, you can go to a common law court and they'll deal with it. Now, we don't deal with statutory laws because they're not laws. But what you do is you present your case to the jury and state that you have suffered harm, loss, or injury. And when you do so, you tell them how it's affected you. You put forward a case, and you can put in a request for damages. Now, we don't turn around and put in because someone has committed a crime and they've asked you to pay a bill. We don't turn around and say, well, we're not paying that, we'll get a decision from the court. But because what you're doing is criminal, we're going to fine him or obviously get a verdict against him for £2 million. That doesn't happen.
Right.
If anything, we are actually 10 times better in the state courts because everything is addressed individually and any punishment is appropriate to the crime and the individual. So you can't turn around and fine someone that's a couple of £1 million when they're on minimum wage.
Right, it'd be a nonsense.
Small position is ridiculous. So it has to be obviously applicable to the crime committed. Now, if we actually turn around and we abuse the system we have, there's no point in having it because we're actually 10 times worse than the state. And what your viewers can think about when you actually think of the common law court, you say, right, okay, we've been doing this for 7.5 years. We've prosecuted judges, we've prosecuted cabinet ministers, ex-prime ministers, we've prosecuted literally everyone you can think of, any of the authorities in the state and different countries, and even judges. Now, having done that, there is a crime, this is in the UK just now, this would probably be applicable internationally. If you produce documentation and you state that it's been issued by a court, and that it's not actually genuine, you're committing a crime of what they call uttering false documents, and that carries with a 7-year prison sentence. So we not only issue court summonses to even judges, and we prosecute them, we issue court orders and verdicts. We do that. If anything that we do was not acceptable, we'd all be in prison. That's not happened. They can't do anything to us. So that alone confirms that what we're doing is correct. Now, unfortunately, when you deal with people, and there's many, many people trying things to protect themselves, and we've tried many, many things. I've done it myself. There are many, many good arguments to be used in different systems available, but they all fail because you're interacting with the state. Now, the point is, what we do is we deal only with common law and the common law argument, and that means authority, jurisdiction, it confirms your standing. We actually have, which is ludicrous, we have, because of the community we're in, we have created a lawful birth date. So at this moment in time, I would presume you don't have a lawful birth date. or you haven't confirmed that with the common law court and the Korean community. So what we're doing is say that if we ask you for a birth date and state you ask them for a birth date, you will both give the same date.
Yes.
However, he says everyone in the world in authority, so-called authority, police, hospitals, doctors, politicians, your next door neighbour, everyone will confirm that that date when you were delivered by your mother, they will confirm that that was a result of carrying you for 9 months. During that 9 months you were living. So therefore, your date of creation, which is approximately 9 months before, you can make a declaration on the court site for a lawful birthday, and that's confirming the date you believe that you were created. So you get your lawful birthday. Now, in the case I just went to in the court, as of recently, they are prosecuting me as an individual, a person, which is confirmed, Mr. John Smith. They then give a date of birth, which is a state date of birth. That was the date that I was delivered. That coincidentally is the date that the person was created. It's not my birth.
Right.
I gave them a lawful birthday. Now, because I gave them a lawful birthday, that means they're prosecuting the wrong individual. Now, I actually contacted the court. They've accepted my common law court documentation, and they've accepted the fact that I have a different date of birth. So that fact alone confirms that they can't prosecute me, because the system with a different date of birth. As soon as you give them the date of birth that the state used, you're creating joinder. So they're going to argue that.
Yes.
If you remove yourself and you create the new date of birth, which is a genuine one, no, they can't say, we're not accepting that, it doesn't exist. It's a fact in law. You were conceived approximately 9 months before, and they can't dispute that you are living. So
presumably you can't give them the precise date of when you've been conceived. I mean, it has to be an approximate date.
Basically, what we do is to allow people to use this. If you believe that your birth was okay, we've said just to the day 9 months before. That's
right.
Okay. If you know that your mother had obviously went over her due date and maybe a week or 2 weeks, you can add it. So it's not 9 months. You can not adjust it by 2 weeks.
Yeah.
If you believe just now that you are premature, what's reasonably acceptable now in the world, that you can probably be premature in even as much as 3 months, and it's just now pretty certain that you'll survive because of knowledge. So you can go back even 3 months premature and we'll accept it. So basically, if you believe or you know that you're premature, within this period, from between 6 to 10 months, you can select a date in there. Now, once you make a declaration of your opinion that that was your date of birth, and you declare on the common law court in the Korean community, we accept it and that's it. So that's no suit for time. It cannot be altered, changed. It's a declaration by yourself, but you can't turn around if your mother delivered you, and obviously you have a birthday with the state. You can't turn around and say, well, I don't like that. I wish to go back 2 weeks and say, well, I was created 2 weeks before. It doesn't work that way. Yeah. So approximately, it says within that band, you get the date. If you do that, that then gives you a lawful birth date and it removes you from the state.
Yeah, no, that's really interesting because the date they've created is an artificial date anyway. Because, you know, that's somebody signing on a document, and we're all supposed to believe that that's it. I mean, it is a bit mad, and I suppose you're quite right when the question it becomes quite a philosophical question. Is, you know, when does life come into you at the beginning? When the egg and the sperm come together, or 9 months later, when you're clearly alive, you're clearly alive in the womb. You've only just got to make the emergency exit.
We don't have to verify everything as a fact because you can't.
No,
but we know roughly it's acceptable within that period of time.
Yes,
created. So therefore, within that period, you can make a declaration of your belief, and that's it. Now, it can be challenged because you were living. Because, your mother obviously was carrying you in the womb, but that's it. Now, they can't argue that. And if they want to argue the date they have, it's irrelevant. But the coincidentally they give is actually the date for the creation of the person, which is not you.
Which is not you. And that, I mean, I just think that is a very interesting point worth letting people sink in, because we're so wedded to this date of birth, and the date of birth is asked every damn place you go, and all it is an event in which 1 minute you're enclosed in a nice warm environment, and the next minute you're on the scales being weighed, slapped upside down or whatever it is, the cord cut. It's just an event rather than the beginning of life. And of course that's what they've taken, but it's in and of itself is an arbitrary date, because you could have been born the next day or an hour earlier or induced or all those sort of things. So it is a bit nonsense. I was going to ask you, when the jury have come to their deliberations, I assume then that the case is solved whichever way it goes, and the judgment is given, and the punishment, if there is one, is given. This then, unlike the old system or the system that's in existence, this isn't then a business about, oh, this now makes case law, that this is a precedent that we now follow. Presumably each trial by jury, each one is individual to the man or the woman who have brought the case forward. Would that be fair?
I would say yes, to a degree. But remember, we have had quite a few cases just now. Now, because you're dealing with different issues, everyone sets a sort of precedent.
Right.
So it is case law under common law. Now, what we can do is, if we had a case predominantly, say maybe a couple of years ago, and there was a decision reached by the court, there is literally no point in having another case convened for the same thing. So what you can do is you can put forward your argument that based on this previous hearing of case law with the common law court, this applies to us, so you can obviously get a remedy rather than just proceeding in the court. But everything we do does create law.
Right.
But it's not their system. We don't use their legal system.
No. So I mean, I'm just thinking, if you have a case in which you have, say, an organisation, a corporation that is demanding money every year for a certain amount of what they claim to be doing stuff in the town.
Yeah.
I can't think what you might call that. But it would be a corporation that is pretending to be an authority, let's say, and they're demanding money, and they point to some policy that they have that we're allowed, because we dreamt up this policy, to come and knock on your door and claim money from you. And if you then say it came to a common law court and the jury said, you know what, there is no basis for this. This does seem to be like blackmail. Pay us or we'll put you in prison, or we'll take your car, or we'll do this. And then so if that then came into the point where they said, yeah, no, that's completely unnecessary, that's fraudulent work, that's corruption, we're not having it, that then makes case law that other people, perhaps millions up and down the country, who may have the same problem with these corporations banging on your door and saying, give us some money because we want it, that would then be thrown, everybody could be released from that tyrannical policy.
What we would actually do is, what we do just now, we can clarify one or two points here, that if people are using the system just now, when they use the common law court site, we do that because it gives us, it establishes our position. Now, if you as an individual, you're a living man, obviously, so they can see a picture of you just now, you could be computer generated.
Well, you never know these days, what with AI and everything.
Same as myself. But what happens is, if you're a living individual, what we say is you can use the common law court decision because it's from fellow living men and women.
Right.
We would require, as that you, or prefer if you confirm your position with the common law court. Now, we don't charge for anything. And because of what happened to Zelle before, and when we set up the common law court, we say, look, this has to be available to people. Now, if you have a family, a couple of obviously parents, and then maybe 2 or 3 children, today they're actually struggling because of the so-called bills you're referring to, as is all the bills that the state have.
Yes.
Between that, between utility bills, heating, lighting, and obviously says mortgages or even rent, you then got your so-called various bills to pay for sanitation, and again the price of food. These people are struggling to put food on the table. So under no circumstances will we ever, and we've not done from day one, will charge for anyone signing up to the site. It's all free of charge. Now, we were contacted by, in the early days, we were contacted by a company in London because they said, look, you can charge for this. Everyone that joins, you can charge a couple of pounds. So we've got thousands of members. But the point is, we'll not do it. Because if you have a family and a couple of adults and say a couple of children, if you're going to sign up, we do things, for example, you record your birth. You can then claim ownership of the person that's attached to you, which removes you from the state. And there are various other things you can do. But the point is, if you do this, you're spending money each time to do that, even if it's a couple of pounds. By the time you pay for the family, it's taking money away from them. So we never do that. We haven't done that from day one, number one. So the system is available for everyone to use, and they don't have to pay. All they have to do is use the reference numbers we're given. So therefore, when they defend themselves, they say, I am a living man or a living woman. I have confirmed that with my declaration in common law court.
Right.
My reference number, and that's it. That's all they need. So they can use the system here through using this information. But because the common law court develops, it's obviously growing, it develops with the people. What we do is when people come up with ideas, we discuss with various people, as is even internationally, say, right, there is something that we can use at the common law court. So we've developed the process. But I remember, and I apologise, you may be listening now, when we set up the situation with the bus, now, we have successfully got children back from social services.
Wow.
Now, it happens that this girl was being threatened with the removal of her child. Now, for no apparent reason, she was on her own and she was struggling, and we thought it's ridiculous. But she says, well, if I sign up and record my birth under this common law court, will that protect the child? And I said, yes. We could actually, recently, just before that, we had someone in Australia was actually granted permanent residency with common law declaration of birth, because we'd actually done that, and they wanted a birth certificate from the state, because she wouldn't do that, but she'd had recorded it with the common law court. When we confirmed that was the case, the Australian government accepted it and granted permanent residency, with obviously a declaration of birth from the passport, the common law court. So what happened is this girl in the first instance, the girl in the UK, she was concerned, so she actually signed up her birth, signed up the child, a declaration of her birth. She then took ownership of her legal title, the person attached to the mother, but then the mother, because it was a child, the mother can claim the legal title for the child. So she made the declaration, claimed the legal title for the child, and then says to me, right, that's fine, that's good. We'll need to notify the social services. Can I get a birth certificate? I thought, no, we don't have birth certificates. He said, no, I want a birth certificate. I said, look, you've recorded on the site, there is a record on the site, this is your number. So then he said, no, I want a physical certificate. We had to go away and speak to a couple of people and borrow some money to actually get a machine to create certificates to do it. But in doing that, we said, right, we'll do it. And we've set it up. He said, but in doing that, we said, right, we'll have to charge for that. So the time and effort in doing that, but we only had a couple of pounds on the certificate. So far superior quality to the state that gives the people an option. So if the people want something, they can actually say, I want a copy. So we do that. And what we've done is we have a court seal as well. So we put the seal with the court seal and bottom. Now, that is probably one of the best things we've ever done, because we're sending documents all over the world, and it's going into courts, it's going into governments, and they're all accepted. They don't.
Right. Oh, that's really interesting, isn't it? So you're creating a genuine public record of like a certificate of somebody's birth or conception, however you want to call it, and that's then being recognised and giving it, because it's the public authority, which it should be. I mean, it's not the blooming bar guilds made up nonsense or the state's load of old rubbish. This is the public saying, we accept this because we are the people, and this is the people's court, effectively.
Yeah. Well, that's what we do just now. So, as I said, everything comes from the people. That's where the authority comes from.
Yes.
And again, given the fact that people develop and say, look, can we get X, Y, and Z? If it's feasible, it's we sit and discuss and say, right, okay, we'll do it. Now, as I said just now, we don't charge for things like that, but we've actually recently come up with a unique approach, which is literally foolproof. Now, we actually have we've used it recently, literally in the last few weeks, and because of the new approach we have with what we're doing, we've put in paperwork just now, and literally within 9 days, we've actually had a company that enforces court fines for the statutory courts, meaning the High Court and the Magistrates' Courts. We serve this company with paperwork, now bearing in mind that they have the backup of the court system. So when they issued a warrant and said they were going to act on a warrant for refusal to pay a fine, we served this paperwork on them. And as I said just now, they've come back literally about a week later and they've dropped it completely and said, we're not touching it. They said, we've ceased this, it's no longer valid. So that was it. Now that was in court in the UK. And we had another one, he said literally the same week. We had someone who was in dispute with a company for a debt. Now, the debt was actually £4,800, but he stood by principles and said, no, this is wrong. And what happened is they've been trying to enforce that, and they've been hassling him for 4 years. Now, for the 4 years, it included a big thing, was 2 or 3 visits by the bailiffs who turned up and were very, very confrontational, bullying. And again, they eventually they said, like, we're taking it to court. So they were going to court, and the individual spoke this and said, well, we're working on documents just now, but because of our position and what we do, and we've also been asked many times, will you come and represent us in court? Well, no, we don't. We don't do that.
No.
We offer a system here. We've got a system. In fact, we've often been asked, can you supply a common law certificate, solicitor? Well, no, there's no such thing. Hey,
right.
Have a common law judge that will help us. Well, no, you are the judges. But in relation to this issue, we've compiled the paperwork just now saying we've got this here, which is literally foolproof. And the guy says, all right, I'm sorry, because of what we're doing just now and because we're developing, they said, we will take a fee for this. They said, we'll do that. I said, fine, not a problem. So we actually done the paperwork. Now, bearing in mind, he had a court date 3 weeks later, and he's been hassled for 4 years. He took the paperwork, put it in. Now, when we put it in, it goes to the court, it goes to the company concerned, it goes to the prosecutor, and also it goes to the Attorney General. It was in England. So we done that. So we sent the paperwork, put it in. I went there. Now the paperwork's on headed paper. It carries the court seals. So it's all stamped, received. It's got a registration number. So it's all done above board. We put it in. 9 days later, it was 3 weeks later, they went to the court hearing. Now the guy says that beforehand, he said, look, do I need to go to court? I said, well, no, you don't have to. But if somebody's challenging me, I always go to court. Because the point is, if you don't go to court, they'll rule against you.
Right.
Go to court, you can argue. I said, so I will defend myself and I go to court. Now,
yes.
They normally find from out of court, they don't want me in again. But the point is, that's what I do. And he said, well, not keen. I said, well, you don't have to with the paperwork. If the judge doesn't comply with the paperwork, we can prosecute the judge. He said, right, if I'm not going. So he did go. So he left it. A week later, he got a letter from the court. Unfortunately, it was a court order. So he got a court order. But the court order from Bristol County Court of this, so it was only a couple of weeks ago. So they had actually came and they said, right, in relation to this case reference number above, the case was called on this day before this judge, and it was on their so-called headed paper with the court logo and all this, and supposedly the seal that was printed, but the judge's name was on. It said the case was called here, we're writing to confirm the judgment of the court. He said, given the fact that neither party appeared, he said, we're now struck off the case is dismissed.
Oh, right.
4 years of harassment, right, over this debt and bullying him and coming up with bailiffs. They didn't even turn up. Now, the point is, because they pushed for the date, they've got to go to court. He said, but the judge has to officially sign off. But bearing in mind, because there's a hearing, the judge gets paid for it. So the judge is going to get paid, but had to call on the day in question. But rather than wasting time on a solicitor, they said, we're just dropping it. So they obviously notified the court. The guy himself did go, so it was called, and the judge just struck it off. So he's now dropped that. So apart from the fact there was a small payment, he's now saved this £4,800. And again, because of harassment, it opens up the door because he'd be entitled to compensation for harassment because he's proven his case.
Yes.
So that also happens with so-called taxation. So the point is, what with the people we have, we've actually, through contacts and friends of friends, we've put this paperwork to a barrister who's been in the job for over 30 years, who's now retired, but he was happy enough to look at the paperwork for us. So when he looked at the paperwork just now, he was actually concerned. He wanted to know who produced it, well, who's we produced it. But the point is, he was concerned about its use, and he effectively turned around implying that this would actually get anyone out of jail. Effectively.
Wow,
He said,
that's powerful.
The paperwork we have just now will address anything that happened in court. Now, if you're speaking about taxation, if you're speaking about loss of property, the loss of your children, your driving, anything, your council tax, anything you want, this will get rid of it. And not only that, but if you turn around and get rid of, hypothetically, something like council tax, because it's criminal, it points that out, you then don't have to pay it, which is confirmed, but then you can then backdate any payments you've made, and you can actually recover the money because you've done your position. So therefore, it opens up the door for them to get compensation anyway, but this will deal with anything. Now, if you had been targeted by the state for some reason, or something was done unlawfully, and as a result you've lost property or you've been bankrupt, but it's 10, 15 years ago, it doesn't matter, because this can be used for that, and it exposes everything that happened. It will reinstate you to the position you could be in. So this is what we're doing, and we've only just been using this recently, but when we've done this in a few cases, we've already jumped in and said, no, that's fine. And that's why I used this in my court case a couple of weeks ago. And when I put it in, the judge confirmed that you had the paperwork. So when I went to refer, he says, I'm not discussing that. He says, I'm arresting you and you run out of court. So that's how good the paperwork is. But as I said, deal with anything. So this will be available if people want to do that. And I said, whether or not you wish to pass on, we have an email address if they wish to write in for help and they want to use it. But by using this, what we're insisting is that they stand as living men, because if you haven't made a declaration to the people, and we're not speaking about the Commonwealth or anything, I'm speaking about the people in general. So if you're standing, you say you're living, apart from being a very good computer graphics, apart from saying that just now, I need to confirm you exist. Now, if I happen to go out after this meeting and go outside and see a member of the public and they ask what I was doing, I say, I was just on Richard Dogs. And I said, who's that? Oh, and I tried to describe who you are. I have no evidence to confirm you exist.
No, true.
Under common law, you don't. However, because you make a declaration of your birth with the common law court, I can then say, well, Richard Dogs, he actually has his own media show. However, he's recorded his birth with the common law court, so he's obviously a living man. There's a record of it. Without a record, you've got nothing.
Is there any chance that you can be infiltrated by bots or people making up people and saying, oh yes, I declare, and a complete mythological people?
Well, what we do is we have people here now. If to overcome the scenario whereby it says someone makes a duff entry, we check every entry. So we check them ourselves to obviously see if they're genuine. Now, what we do is the common law court concept, and basically the community you have is based on remaining in honour.
Yes.
If you turn around and wish to use the facilities, we take it that you're honourable. So therefore, you can put your information in. Now, we're not going to challenge it. We're saying, right, you made a declaration, we'll accept it.
Yeah.
However, we find out that that's fraudulent. Not only will you be removed, but you can also be prosecuted by the people in the common law court for what you've done.
Yes.
Therefore, if someone gets to, we will obviously do that. However, when we set up, we were getting entries for date of birth for Mickey Mouse. As I said.
Right.
So you've got the obvious ones, which are ludicrous.
Yes.
Again, based on remaining in honour and making a declaration, unless somebody's going to challenge it, we take people at their word. However,
Right.
that doesn't guarantee protection. Because if it's fraudulent, they will actually be prosecuted. Now, if you're prosecuted by the common law court, that's actually worse than the statutory court. Because if you're prosecuted by a statutory court, the judge, so-called judge they have, has guidelines. He will say, for this offence, I can imprison you, I can fine you, and are in bounds to do as they're told. If common law court, if you're brought before a common law court, a jury, you then have done something wrong, that is presented to the jury. The jury will then give any decision they want. It's basically free legal for one.
Yes.
What we do is you cannot do this and say, basically what we're going to do is we're going to obviously get a decision, and obviously we're going to try this, or we're going to be ridiculous with it. What we do is say a decision, because the common law courts are honourable and they're superior to the state courts, we say we're happy to prosecute someone, but to find that they're guilty, there should be no dispute. Now, they're guilty or they're not. Now, it's like a child. When a child grows up at birth, when a child grows up, even at a couple of years old, the child will know right from wrong.
Yes.
So it's that obvious. So if you sit down with a jury and you present evidence, based on the evidence, they will then say, right, okay, yes, there's sufficient evidence they're guilty. And that's it, they're guilty or not.
Right.
If there's any doubt, between that and being guilty, it obviously it opens up a question mark. But the point is, we're saying, if we have a jury, we will only accept a guilty verdict if it's unanimous.
If it's unanimous.
So
Can a common law court, you said earlier that it deals with living men and living women. I'm presuming now then, if you wanted to take, say, a business or a corporation to the common law court, would you have to have an individual who works for that? You couldn't take...
We only deal with living men and women. So
right.
If you want to take someone in charge of a company or a company dispute or a government, what you do is you prosecute the individual who's in charge.
Yes, because the corporation is and of itself not a thing.
No, and when you prosecute the individual, you prosecute the name, but after the name you say so-and-so acting in the capacity of, and you put the title down.
Right, yeah. That makes a lot of sense.
The crime is committed by the individual. They are prosecuting common law, but the crime is obviously what this individual's done while in that official capacity.
Yeah, well, that makes a huge lot of sense. We're seeing at the moment the sort of corporation takeover. Everything is becoming corporations, and nobody is taking liability for everything. We get these letters, don't we, that nobody's signed you, and you're talking to a dead entity, and you think, well, you don't even exist. Why am I paying for these services that nobody anywhere is actually party to? So this does seem to be a great way to sort of bring it back to the people again, so that people are much more in charge of things.
What I will say just now, just to let your viewers know, is that basically we prosecuted someone in relation to the issue of council tax. Now, as we forget about the issue of council tax anyway, but what we've done is we've confirmed, even through the common law court, that it's illegal, it's unlawful to do that. So we prosecuted someone and we've issued a court order for them, which they ignored. Now, they've ignored the court order and thought, right, okay, that's fine. He says, so we gave them a chance, and we've not done it. Because of what we've established and confirmed that the orders are valid, he says they can be done for contempt of court. However, to enforce this, we decided to proceed. So we went to the council and we said, right, okay, this individual is guilty. He says they have to be removed from their position, but they have a fine which they're refusing to comply with. Therefore, as an employee, the council is responsible. We want a copy of your insurance details for cover because we're going to put a claim. Now, they actually turned around and said, well, no, you're not getting that. I said, well, you don't have a choice. It's a valid claim. You need to put this in. And he said, well, we need to see the order. So we gave him the order. He didn't come back. They were given 10 days to do that. And then when they didn't come back, we contacted this individual. He says, look, you failed to come back. He said, now, we're not going to stay that you're complicit in crimes. We're going to say just now that you failed to respond, so we're giving you 48 hours to do so. He said it may be an oversight. He says, however, failure to do that will confirm that you are complicit in crimes. He says also, the failure to provide the insurance details, we will contact the insurance company directly. We'll tell them that you're refusing to hand out these details for a valid claim. He says, and it's as a result of the criminal employee that you have, who's a convicted criminal for committing crimes against the people. So he gave him that. Within 2 days, he came back with insurance details.
Wow.
Went on to the insurance company, which is Zurich. So went on to Zurich, and it took 4 calls to get to the right individual. So we got to the individual, and then said, right, you have the order. And they said, right, okay, that's fine, no problem. Can you forward it? So we forwarded the order. And they says, fine, well, we have to get the solicitors to deal with it. He says, that's fine, we'll pass it on to them. So they passed it on to a law firm. It says Waitman's in Manchester, Liverpool, Manchester, Liverpool, Waitman's office there. And this individual come back and said, right, okay, I've just got this, what's it all about? So he says, well, it's a court order that's been issued. He says, which needs to be enforced. Right, okay, can you forward it? So I forwarded it. He says, fine, okay. He said, well, and I phoned them. He said, well, we've never heard of the common law court. I said, well, it's irrelevant, it's a court order. He said, yeah, but we don't know. This is what this is. I said, well, it's a court order. It's been issued by the court. He said, you've got the paperwork. He said, yeah, but we don't know. He says, are we allowed to appeal that? I said, no, it's a court order for the people. You cannot challenge it. It's done. The only thing you need to deal with is enforcement. He says, so you need to pay up. And I said, no. He said, well, and she sent an email. She said, right, as far as we're concerned, Zurich won't pay any valid claim. However, looking at this paperwork just now, we've actually informed them that it's not valid. I thought, oh, that's fine. So I wrote back to the solicitor and said, right, first of all, he says, what you're stating is nothing more than an opinion. He says, and while your opinion may be relevant to you, it's worthless to us. He says, however, if you're going to deny this as a valid order, you have to base it on a legal authority. We want you to confirm the legal authority you're relying on. This is the failure to do so. This is the valid order and you must comply with it. She didn't get back to me at all. For 4 weeks, wouldn't get back to me. And basically, I then complained to the firm, Waitman's. I went on to our boss. I was told she was in the office. I was told to put the complaint in. So we put the complaint in. She never got back to me either. Now, what happened literally last week, on Friday, at the end of the close of business, we hadn't heard from Zurich for ages. Zurich came back to us with an email and said, look, we have obviously said we're aware of this process just now, we're looking at this. However, it is we're writing to confirm that the council, the local authority concerned, have written to us. They have informed us that they no longer wish us to indemnify this claim, and they have said they're dealing with the matter internally. This is what this is sufficient for your needs. However, we're aware that the solicitors have been told the same, so I think they'll be removing themselves as well. So that was it. Now, on the Monday, the solicitors came back, but the solicitors were employed by Zurich. And the solicitors came back and says, further to correspondence, says that when in top form, the Zurich has removed themselves. We're now informing you that we're no longer paying this and we're removing ourselves. And if you wish to speak this on to the authority, then that was it. And Zurich had said, if we write them in relation to this matter, they will not answer any correspondence. Now, what that's done is Zurich are the insurers. Zurich have to pay valid claims. The solicitors said that they will pay a valid claim. And it's a valid claim because we have a court order which is accepted by the state. However, in relation to the dispute and the authority, because this was going on for a number of years, we actually contacted the authority and we've done a data subject access request. Now, the authority were at pains to point out that we can do this. However, it's based on personal information. If you're going to proceed, you have to provide valid proof of ID, name, address, date of birth, and photographic ID. So we put in common law court documents. The common law court documents, the common law passport, were accepted by the council as legally competent, so they've accepted it. But when we produce a court order, the same authority, they'll say, well, we're not accepting that because they can't do it. It's already accepted. So we pointed that out, nobody speaks this. So we're actually waiting to contact the authority now, having just heard of this. So we're actually now going to contact the chief executive officer and say to them that we need them now to settle up because they have actually told the insurance company not to pay it. But the point is, they said they're dealing with the market internally, which is fine. So I think the problem is Zurich do not want to pay, because if they have to pay for that, it means every single claim for council tax will be refunded.
Yes.
So they're not doing it. Yeah, they're not doing it, and they've actually spoken to the council, so they've actually come and said, right, we'll deal with it. So the council have taken on the solicitor, they're going for cover. We're now dealing with the council, and at the end of the day, if the council don't deal with it as well, the councillors will be held accountable for obviously the behaviour of the administration side. So we are enforcing these things, and we are having success.
Well, that is amazing. That is amazing. And of course, I guess, you know, it's early days, because once more and more people accept this, the authority will just grow to become much more dominant, and the old system will crumble away. John, I only like to keep these interviews for an hour, and I think we've just spoken over an hour, which is incredible. It's an absorbing subject. Where can people find out more information and join up if they so wish?
We provided some links to yourself, but basically the site is commonlawcourt.com. That's it.
That's it.
So
commonlawcourt.com.
The only thing we'll say is you don't have to fill out anything on the site, but to access the site fully, you create an account. Now, when you create an account, all you do is provide an email address. That is your username, and then you create a password. But when you go onto the site, if you're using the site to fill out any of the forms, always use your email address, the same one, because obviously it keeps everything nice and tidy. But that is also your username. But if you do that, that's fine. The main things we would say just now, which is on the home page, is literally those four. I would suggest confirming your birth. Now, by making a birth declaration, it confirms a few things. It confirms that you were delivered on a certain date. Now, while you were delivered, is although we're saying that that's a birthday because the state accepted it, it's a date of the person was created. However, this is what you're doing is saying that that date was accepted by the state for the birth. However, at that time, you were living. So it's a confirmation from the common law court. You can then apply for ownership of your legal title, which means you can take ownership of that, which removes it from the state, and then you can create a lawful date of birth, which obviously then confirms that you were living for 9 months before. And not only that, it then makes it difficult for the state to prosecute you because they can't use that date of birth.
They can't use the date.
And not exactly. That. This is if obviously people decide that they want to obviously continue with this, they can join the Korean community. But as I said, the common law court exists to provide a lawful remedy, is there. People turn around and say, we need something, we need a community, we need to work, we have the Korean community there. Free of charge, people use it. And instead of dealing with lots and lots of other things, which obviously they're all valid arguments, they're all applicable, but when you use them, the state ignore them. They ignore Mark, ignore Magna Carta, they ignore UCC and everything. They're all right, they're all correct.
Yes.
Judges say, well, not accepting it, you can't do anything. Whereas, by using this in the common law court, they can't challenge it because it's out with their control and authority, and it's all under common law.
And it's above their authority. That's the key thing.
And as I said, in relation to this, while it's common law, we actually called it out because most people, English speaking, understand common law and the concept. But the thing is, this is applicable to everything. Now, it can be natural law, it can be universal law, it can be the law of the land, it can also be called God's law, or depending on the religion, the Creator's law. It doesn't matter because the four founding principles, as you said.
Yeah, absolutely. Listen, John, I'm going to have to bring it to a conclusion, but thank you so much for outlining that and telling us about it. I think it will have given people a lot of information, a lot of things to think about. The commonlawcourt.com is the website. People can go and check that out. They're probably already sitting there going, hang on, 9 months back, where was I at that? Which will give them a different, if I think about 9 months ago when I was born, it gives you a different perspective on who you are as well. That's a fascinating thing. Brilliant. I really appreciate your time. It's been a great conversation. Thank you so much. I'm sure we'll be in touch again. And let us know of all good...
Thanks, Wild Horse.
Yeah, you're welcome. I accidentally ended it soon.
Yeah, we know how that goes. with the ending of those videos, they can end for way too long.
Realize you are the common law court, right? I am the common law court.
What did you think about their take on the birth date? Obviously, that's something we never confirm, but the 9 months back from our born
The date of
date.
conception? The date of conception? Well, we have two different dates. We have the original recording date of the entity, that state agency was created, the original recording date versus the delivery date. You have the date of conception, and then you have I was conceived in the mind of God before the beginning began. I predate the whole entire system. I came first.
I like that one.
Mm-hmm. So we have the registration date, original recording date. If you go into court and you bring in that original recording date, oh, there's a error in the record. This is the proper birth date for this person. I wrote to the Secretary of State a letter and talked about all the different types of entities, like the partnership. The partnership goes into exist as the time of the partners signing for it versus a corporation when they get a registered agent versus a trust. And there's all these different trigger dates when the entity is finalized. And they said, what essentially is the birth date for the state agency birth certificate? And she wrote back, it's the date it's recorded in the registrar's office. So I use the word. What is essentially the birth date for the state agency birth certificate? So they admit it. The state agency birth certificate has a recording date, birth date. Make sense? I wrote the vital records.
Yeah, I like that. I like that version. Much better. I've heard the come back to I can't give my full details because that was presented to me and it's a present, which is
and who would you be saying that to?
Whatever authority questioned.
Like what? Give me a scenario.
Or wanted it.
Like what scenario?
Well, you're in a court and you're dumping off, you're actually delivering paperwork for a friend that can't make it to that court date and has no.
Okay. And what
has no.
So you're filing some paperwork. You're putting some paperwork in.
And they want to know who you are. They want to know if you're a deputy.
I'm a courier. Write up a work order. Yeah, right here I have this work order. I'm supposed to come here and drop this off. And then
they want to know if you're insured if you drop off that paperwork.
I've never had anyone ask if I'm insured if I'm going to go do something like that.
No, they haven't asked if they're insured. They just want to know if you are so they can ding you.
I don't know what you're talking about now. Never in my time have I ever been insured or dinged or anything else because I have a work order to come do what the work order tells me to do. Never had anything like that. In fact, it's
they're asking you for your name for that purpose.
No, they are not. They have never asked for my name, ever, for going in and doing process there at the clerk's counter.
Nice.
Never.
You're not in a communist state, then.
I have a work order. I draw myself up a work order, and I'm the courier. And what's good about that is, like, I try to get something recorded in California, Riverside County, off Washington Street, off the 10, and this lady was hostile. Of course, they're all hostile working in Riverside County. And she said, we're not able to record this. And I go, well, can I get a rejection letter? No, we don't hand those out. I said, well, I'm just the courier. I need to take something back to my principal to show that I did some work so I can get paid and go to Vegas. And she started laughing. Oh, she became nice. Okay, we'll write up a rejection letter for you. Because if
You
I'm the
broke
principal,
the ice. You did the compliment.
I'm not the principal. They're not going to tell the principal what the principal did wrong. Because I, as the courier, can demand a rejection letter so I can prove I did my service so I get paid and go to Vegas. It's just a workaround. That's why I talk about Vegas all the time, because then she's talking about Las Vegas. She's not thinking about working in Washington Street in Riverside fucking County out there in the freaking desert. She's not thinking about Vegas. She was happy after that, too. She really was. Her whole demeanor changed.
Write a purchase order. That's a good one.
No, it's not a purchase order. It's a service order.
Service order. Okay, so it's got a PO, correct? So you're going to bill for your time. You're billing for your time. Yeah.
A job number. And you give it, like if you're going to hand it to somebody else to do, just write it up, like a job number. Here you go.
I wish I would have thought of that. No, I'm going to be doing the same thing at Supreme Court, so I'll see if I get the same resistance.
What are you going to Supreme Court for?
To enlarge my complaint into my existing...
Complaining about what? Theft of the car?
Foreclosure? No. Theft of my land. To my 2 pieces of land.
Did you go back and file an order to the court coming in as surety and ordering the judgment creditor to sue the debtor within 30 days?
Well, that's what this is.
What?
That's what this is, a notice of claim.
I'm not...
Notice of adverse claim, correct.
No, I'm not. That's not what I said. I'm issuing an order. You're making a claim. 2 different things.
Well, I'm going to just do what Holly told me to do.
Okay, it could be true. It's just not what I'm talking about. So that's cool. That's good. We'll see what happens. You go in there making a claim.
I'm not going into anywhere making a
claim. Okay, you win. See what they do. And what's your capacity going in there making the claim? Who are you in this claim?
The surety.
Well, the surety doesn't make a claim. The surety gives an order. If whoever the mortgage company is says they didn't get paid, so they're foreclosing on the property because they didn't get paid, then I, the surety, want the judgment creditor to go sue the debtor. Well, they go sue the debtor. Don't come after me. I already put in my bit. I'm the surety. Go to the debtor to get paid.
Well, that's the issue. They've been paid over and over again.
Not the issue is you haven't told the creditor to go sue the debtor. They let you set up as presumptively the debtor in the whole situation. They're coming after you as if you're the debtor, but you're the surety.
That's correct. So I have to correct the record.
You know how you correct the record? You come in as surety. I order the judgment creditor to sue the debtor within 30 days, at which point surety and surety interest are exonerated and remit all security interests and property back to the surety. Return all my shit. And the surplus. Remit.
They used my shit without my consent.
Okay, you're right.
All judges' actions are supposed to be reviewed. They weren't.
Has anyone got a burning desire or question?
Burning desire. Sounds like you should go see the doctor.
What does that job order look like? Does it look like an invoice?
I don't know. Go Google it. But if there's a burning desire, you should go see a doctor. Is that the question? What should I do about a burning desire? Is that the question? You should go see the doctor.
Nah.
Hey, you just mentioned. I'm sorry, I got a kind of a question. You just mentioned accepting the position as the surety.
No, not accept it. You are the surety. You signed the paperwork that created the money.
Oh. And so, as a surety, you do what? You tell the debtor to pay the creditor, or the creditor to.
You order the judgment creditor to go sue the debtor. They did. If the creditor didn't get paid, they go sue the debtor. The surety already put my paperwork in. I funded the whole thing. Now, if the creditor didn't get it, then go sue the debtor.
Wow, that's very simplistic.
The debtor's the treasury. The treasury always pays. Always. It creates the impossibility. And after 30 days, surety and surety interest are exonerated. You go to Gibson, 632, I think it is, somewhere in there. Talk about suretyship, subrogation, and exoneration. It's in Gibson's Suits and Chancery. And it tells the format of the exoneration. As surety, you already have authority. Hey, what'd you do with my money? I put it in there, and you said you didn't get it? Well, you can go after the debtor. Go after the debtor. I'm going to give you orders what to do with my shit. That's my money. I'm going to tell you what the fuck to do with my shit. And if you took a bunch of stuff, and I'm the surety, then give it back to me. I don't get to keep it, judgment creditor. I'm the surety. I paid for it.
Who would be the creditor then?
Whoever's claiming that they are owed money. Mortgage company.
Creditors.
Mortgage company, card company, credit card company. Anyone who claims that they're owed something. Really? So you didn't get paid? Well, they go sue the debtor. So I know I signed a credit application that created the money right then. Instantly.
Wow.
I'd like to sue my all caps name, or sue one of my other persons for being an incompetent minor.
I don't know what that means, but yeah. You have a social security card. You have access to the treasury. I remember, who was it? What was his name? Big Grave. He sued his all caps name and made a settlement. And whatever. What's his name? I can't remember his name. Remember he said the birth certificate's a state agency way back in the day, 7 years ago. I haven't heard from him in a while.
Sound like Winston Shrout.
No, it's a dude. God, I can't remember his name. He was all the rave 7 years ago.
David Strait?
No, David Strait's in jail, isn't he? Or his wife or somebody? David Strait.
Yeah, his wife.
He was a SEAL. He was a SEAL. Huh. Is it Ken? Ken W? What's his name?
You just said, as holder of the Social Security number, we have access to the Treasury.
Fill out an application, yeah. They authorized the extension of credit from the independent treasury. Independent treasuries, the Social Security. Independent treasury versus the U.S. Treasury. Where are you? Oh, there you are. Walking the cat. It's freezing. It's freezing.
Treasury in Puerto Rico?
Just type in independent treasury.
Independent Treasury versus the... What are you showing there, Wild Horse?
Nothing. I was just looking up some terms, and this popped up. So I'm just reading it, getting a grasp of it. But I was thinking when you were talking about the Social Security card, the letter on the backside corresponds to a specific Federal Reserve Bank. So I was wondering if that would be the place. But then when Smoking Baby said an independent thing, that blew me like for a loop. I had to think about it.
I think the independent treasury is in Delaware.
Salty cracker.
Look what it says here on the graphic, though. Number 5, column row 5 under debtors. It says, what is it in accounts? Okay, under the debtor, it says debtors are an account receivable. And then creditors are an account payable. They're not even saying that they're an entity, they're just a thing.
Depends on which side of the table you're on. The creditor on one side of the table is the debtor on the other side. Depends on how you look at the ledger. They're inverted. Accounts receivable, accounts payable.
Is it called the debtor? Is the let me see. The defendant is the creditor, and the plaintiff
Plaintiff
is
is the
the
debtor. Plaintiff is a debtor. Defendant is a creditor.